September hasn't been because she was still in, I believe, junior high at the time. A number of you have been here a long, long time. Many of you have heard me speak several times. I always say the same thing. I say it differently each time, but it's really, there's only one message here, and I'll try to deliver it one more time. Maybe it's my swan song with you all. And that's really to talk about how the program began, how it's evolved over time, and then at the end I'll wrestle with some of these issues that you all introduced earlier, which I think we owe an explanation to you about where we stand on those issues and our thinking, and it will be part of that evolutionary process. So let's sort of think back 20 years when Congress first introduced the legislation. This isn't the full piece of legislation, but it includes most of the pertinent terms. There were 3 years when this legislation required that the funding be provided to the Administration for Native Americans, which is part of Health and Human Services, 1993 through 1995. But in 1996, we took over the program, 20 years ago. And the language that Congress has used each year for the 20 years has never varied. This is it. Pretty short, pretty simple. There are no definitions. There's virtually no legislative history. Very little for lawyers to draw upon to try to interpret what Congress intended other than to look at the bare language. So that's what we've tried to do over 20 years. Is we've tried to give voice to what we have believed to be Congress's intent in enacting the legislation. And that was, in our view, twofold. One, to accelerate the cleanup on Indian lands attributable to past DOD actions. It was apparent to the members of Congress who were principally responsible for this legislation, Stevens and Inouye, that cleanups on Indian lands were not progressing very quickly. And the reason for that was at least logical in some respects. That is that in many cases, Indian lands were quite sparsely populated. And so the threat posed by the contamination, at least on a sort of a logical sense, was less pervasive and less demanding on these sparsely populated lands. And so in a rank ordering, when you're ranking sites based upon risk, they fell into the latter end of the list. And that didn't seem right to Senator Stevens and Senator Inouye. So they created this legislation to address that problem in light of the federal trust doctrines. Because that's what I think in part drove their decision to enact the legislation, was that they didn't believe it was fair to simply say, we'll get to you when we get to you, because we weren't getting to you. And they believed that the federal government had a responsibility to address these problems that we had created, and so they created this language in our behalf. So we received the legislation, 1996, we had some decisions to make. The first decision of it was how we were going to execute the program, because at OSD, our staff is quite small. There's Joe, his predecessor three times removed. There's Maureen. There's a lawyer who has advises the program. That's been me for the entire 20 years. And the contractor staff that we've retained, Kara's, through Darlene, and some of the folks with whom she's worked. But that wasn't enough to execute the program. So early on, we adopted the process of, or the decision was made to use the Corps of Engineers. And we use the Corps of Engineers principally for two reasons. One is they had a geographically distributed field staff, which makes it a lot easier for us to work with the tribes individually to develop the cooperative agreements that we use as the basis for transferring the funds. So we needed some entity that had that distributed field staff, and that was the Corps. And secondly, we had a long history of working with the Corps of Engineers through the Defense Environmental Restoration Program, and it had, in most respects, been a positive relationship. And we were comfortable working with the Corps of Engineers. So as a first decision, we chose the Corps of Engineers as our execution agent. The second decision we had to make was how to transfer funds to the tribe, how to get the work done. And we had choices to make. We could have used a contract. That is, we could have asked the Corps of Engineers to enter into contracts. Contractors would have come on Indian lands, address the problems, so long as you tribes were willing to allow them on your lands. We chose not to use a contract simply because we thought it was too prescriptive, really too dictatorial. From the beginning, we thought this is a program that ought to be done in a cooperative fashion, where we, the Department of Defense, working with the tribes to affect the cleanups. We could have chosen grants. In a grant situation, the government gives the money to the grant recipient, and they do whatever they do. We didn't think that was really the most appropriate mechanism, although there were tribes who preferred that and voiced their views to that effect. We didn't think it was an appropriate way of doing this because we, the Department of Defense, ultimately are responsible for the cleanup. We have to stand behind it. And so we didn't think it was appropriate simply to hand over the money and walk away. So that left us with the cooperative agreement. It's a perfect tool in this circumstance in our view, because it anticipates that we will work together to effect the cleanup. And that's what we based our relationship on ever since. One little quirk here you should be aware of, under fiscal law, federal agencies have the inherent ability to enter into contracts without additional authority. But in order to enter into either a grant or cooperative agreement, we need express authority to do so. The language I showed you a few moments ago that set up the NALEMP program doesn't include that express authorization to use a cooperative agreement. So the way we got around that obstacle is we adopted the Cooperative Agreement Authority in the Defense Environmental Restoration Program, which is at 10 United States Code 2701D. And the logic there was that the sites that we were addressing on Indian lands were actually a subset of the formerly used defense sites that we address under the DIRT program more generally. And that entitled us to use that express cooperative agreement authority to enter into our cooperative agreements. And that's the logic we've been following ever since. As I said, I think the cooperative agreement is the appropriate tool for the relationship we've developed with our partner tribes and Alaska Native entities. And the reason for that, I believe, is that we have several objectives in using the cooperative agreements. Certainly we want to remediate whatever environmental problem it is that is the subject of the agreement. That's the basic desire, is to remediate the problem that we've created that continues to have consequences for you. But beyond that, we do believe that we have an overarching responsibility to address the government's larger obligations under the federal trust doctrine. I think some of you may recall a few years ago I sort of gave a talk that emphasized this particular issue. And it's really an interesting question of Indian law, whether the federal trust doctrine is a legally enforceable obligation that a tribe could enforce against a federal agency, or whether it is simply an expression of a moral commitment on the part of the United States government. The case law is pretty mixed up in this regard. Generally speaking, it comes out concluding that while the United States government acknowledges its responsibilities under the federal trust doctrine, it satisfies those responsibilities by simply satisfying requirements of laws of general application. I'm letting that sink in for just a moment because it's sort of pregnant with implication. In my view, the implication of that is they've read the federal trust doctrine out of existence as a legal obligation. I'm sorry to say that, but I believe that's the outcome. But the interesting thing is there's a line of cases that concludes that whether enforceable as a legal matter or not, the federal trust doctrine may be relied upon as an independent source of authority for a federal agency to undertake actions that they otherwise would not be obligated to undertake. That is, it empowers us to spend our money to do things we otherwise couldn't spend our money doing. And so it's important in that regard, and we're using the NALEMP program and cooperative agreements to satisfy what we believe our responsibility is under that doctrine. And lastly, and this is why, again, cooperative agreements are the appropriate tool, what we were hoping to do when we decided to use cooperative agreements was involve the tribes to the extent that the tribes themselves wanted to be involved. We're not requiring tribes to take on the full cleanup, but we're happy to make that happen as the program matures. We wanted the decision to be a tribal decision as a reflection of the doctrine of self-determination. To give you just an example, our very first cooperative agreement, which happened not to occur under the NALEMP authority, actually, was with the Suquamish tribe in Puget Sound. And for years and years, the Suquamish tribe had been commenting on cleanup documents that we had prepared as part of our Defense Environmental Restoration Program without having been compensated for the expertise they brought to that task. And so we entered into a cooperative agreement with the Suquamish. This is more than 20 years ago, 1995, I believe, to compensate the tribe for bringing that expertise to the table. It was both technical expertise and it was expertise reflected in their knowledge of traditional ecological knowledge, the fact that they have a place-based understanding of the location where these cleanups are taking place that no one else can bring to that table. And in all fairness, they ought to be compensated for providing that. So there are a variety, there's sort of a continuum that represents the relationship between the Department of Defense and our partner tribes in this program. In some cases, the tribes are rather are not as significantly involved in the cleanups as in other cases. But we do have cases where the tribes are carrying out the cleanups almost independently and to the extent that they've developed the economic or business capacity to provide that service to first persons outside of our program. The bottom line here is it's a choice the tribe makes. That was the key. So back to the Annual Appropriations Act, so I can talk about language, so I can talk about just a couple of matters. Look at this language again. No legislative history, no definitions. There are at least three terms that deserve elaboration for us to understand how to administer the program. What are environmental impacts? What are Indian lands? And what does it mean to say resulting from DoD activities? So I'd like to walk through each of those. First, let's talk about environmental impacts. What is meant by environmental impacts in the context of the NALEMP language? Generally speaking, we believe those impacts are intended to be coincident with the kind of impacts that are addressed under the Defense Environmental Restoration Program. And that's sort of important because, remember, we are relying upon that express authority to enter into cooperative agreements from the Defense Environmental Restoration Program. So to the extent we get outside of that, we're on thinner ice, if you will. So that includes contamination. You're all familiar with that. It includes other types of environmental damage that presents an imminent substantial endangerment. That's principally unexploded ordnance and munitions-related concerns. And lastly, demolition and removal of unsafe buildings. Now, demo and the removal of unsafe buildings under the normal core FUDS program is done incidental to other activities. In our program, it can actually be the centerpiece of a cooperative agreement. We've entered into any number of cooperative agreements where that's the principal activity that's going to take place. And the goal here is to make these lands available for the tribe to use as the tribe wishes. To make these lands available for use as the tribe wishes. And that, again, is a reflection of that trust responsibility, because as the trust responsibility was originally conceived, the idea was that the federal government, as it entered into agreements with the tribes, whereby the tribes would provide lands to the United States in return for the United States protection on the lands retained, the idea is with respect to those lands that were retained, the United States would ensure that they would neither be intruded upon by settlers, that was the case in the 1800s, nor threatened by environmental threats, which would be the case today. So that's really the heart of the federal trust doctrine. The question arises occasionally, more than occasionally, about does the term environmental effects or environmental consequence embrace concerns that are largely cultural? That is, cases where whatever we, the Department of Defense, did historically diminishes the ability of the tribe to engage in these cultural practices. Are those included? Well, there are a couple ways I think that I would answer that. One is to recognize that with respect to most tribal cultures, there isn't any distinction made. The environment and cultural activities that take place there are really inextricably linked in a way that they can't be separated apart. And for that reason, it seems to me that we ought to be willing to embrace concerns that we've created that affect the tribe's ability to engage in those cultural practices. We've tried to embrace that in the decision-making process that we use under NALEMP. So we have that LifeWays criteria that we use in helping us to make a determination about which projects we're going to fund in any particular year. And with respect to LifeWays, we're talking about a customary way of living. You know, I once heard a friend of mine gives a talk about what is culture? And his rule of thumb, or his basic definition of what is culture, is it's the way we do things around here. And when you think about culture in that broadest sense, what we're trying to do through the NALEMP program is ensure that the tribes can continue to do things the way they do things around here, not be affected by the things that we've left behind. So we try to interpret the term environmental impacts quite broadly with respect to the NALEMP program. The second term that I'd like to sort of puzzle out just a bit, and it will introduce a couple of these questions that were raised earlier this morning, is what did Congress intend by the term Indian lands? Well, certainly it meant lands located within the boundaries of an Indian reservation, Pueblo, or Rancheria, and the trust lands and other restricted fee lands. That's the category that's the cleanest category. And if you were a lawyer who looked at the term Indian lands in the pure real property sense, that would be the category of lands that you would typically think of. We've never looked at it in a strictly real property sense. Right from the beginning, for example, we determined that, see, we're not entirely stupid. The legislation was originally introduced by Ted Stevens to address sites in Alaska. If we had stuck with just the first two categories, we'd only address one site, that would have been the Metlakatla tribe. We knew that's not what Senator Stevens intended. He intended us to address a lot of stuff we left behind in World War II, and the only way we could reach that was by interpreting the language Indian lands to include those lands that were transferred to village and regional corporations under the Alaska Native Claims Settlement Act. So from the beginning, that's how we interpreted it. And we took that interpretation to Senator Stevens' principal staffer at the time. Her name was Sid Ashworth. Her name still is Sid Ashworth, by the way. She just doesn't work on the Senate anymore. And she confirmed that that was a reasonable interpretation. And then at the time that we were trying to interpret this NALEMP language, we were also finishing negotiations with respect to that Suquamish cooperative agreement, which was done outside of NALEMP, but the precedent that was set there sort of bled over. And of course, in the Suquamish case, we were principally concerned about impacts on their tribal right to hunt, fish, gather, and graze off of their reservation lands in usual and accustomed fishing locations. And so right from the beginning, we interpreted our authority under the NALEMP program to include tribal reserve rights on off-reservation lands. Now, most of those occur in the Pacific Northwest and in the treaties that the United States entered into around the Great Lakes. But it did open up the aperture with respect to the program wider with respect to those locations. That leaves us with the more interesting question that was raised earlier this morning. And that is, what about subsistence activities and ceremonial uses off of Indian lands that weren't reserved expressly in a treaty? Well, there are a couple ways to think about it. There are some people who would argue that if they weren't expressly reserved, they were lost. That there then is no legal protection for those subsistence rights or the right of a tribe to visit a sacred site or other ceremonial location, to gather medicinal plants, those sorts of things. The counter-argument is that very few Indian tribes actually, Indian treaties actually include express language reserving rights off Indian lands. And they are principally those in the Great Lakes area and the Pacific Northwest, each of those sets of treaties having been negotiated by a single man in each case who repeated the language with respect to those treaties. With respect to the rest of the country, the treaties are generally silent with respect to off-reservation rights. How should we interpret the agreement that was reached between the United States government and the tribes in those circumstances? Well, the general thinking here is that we first apply what we call a canon of construction. Lawyers have words for how we interpret things, and there is a canon of construction with respect to Indian treaties called the doctrine of sympathetic construction. And the idea there is that we understand, we attempt to understand treaties as if as the tribes would have understood them at the time they were entered into. As the tribes would have understood them at the time they were entered into. So what do we conclude with respect to tribes that entered into treaties in the 1850s that didn't reserve the right to hunt fish off of the retained reservation lands? So these are tribes that gave up huge amounts of land to the United States government and retained relatively small reservations. Do we conclude that they intended to confine themselves to the lands retained? Or do we conclude that they were willing to live on these smaller reservations so long as they had continued access to the resources that were absolutely critical to their cultural identity and their way of life? Now, if you apply this construction, sympathetic construction, and try to look at it through their eyes, it seems to me it's more logical to conclude that they felt they would always have the right to continue to fish and hunt and to visit ceremonial sites off the reservation lands, and that we ought to interpret those situations that way now. And it seems to me that's particularly important in Alaska, where you don't have treaties at all, and you have this sort of artificial construct the Alaska Native Claims Settlement Act layered upon Alaska, and then to make things really a little more complicated, I think less concrete, you have ANILCA having concluded that subsistence use in Alaska is a rural concern, not just an Indian concern, which sort of, I think, makes it very difficult to interpret what may have been intended. But it seems to me, again, if you apply this canon of sympathetic construction, you still reach the conclusion that we should be mindful of the fact that tribes expected to be able to use the lands that were given up for the practices that were central to their cultural identity. And that's absolutely clearly the case with respect to the tribes that use the express language like was used in the Pacific Northwest. In fact, as you know, the reservations that were retained by the tribes in Puget Sound are quite small, and that was with the express concurrence of Isaac Stevens, who did the negotiations on behalf of the United States government, and his thinking was this: if I continue to allow the tribes the right to fish, in particular at usual and custom fishing areas, I won't have to provide as much food to the tribes outside of that practice. They'll be able to feed themselves because there's plenty of salmon, and they'll just continue to feed themselves through the salmon. Now, I didn't anticipate that we were going to decimate the salmon population, but that was the thinking when we entered into those treaties. So, long story made longer, we attempt to apply that thought with respect to making decisions about the eligibility of sites under the NALEMP program. So that if you come to us with a site which is attributable to past DOD actions that affects your subsistence or ceremonial practices, and they are of long standing, and they have been continual, and I don't mean continuous, I mean continual, that is, there's at least been a desire to engage in those activities. I understand that in the lower 48, there may be long periods of time when you were not afforded the opportunity to exercise those rights, and where they are of current significance, that is, they're still important to the tribe maintaining its cultural identity, we will try to address those sites. Now, the second half of that particular concern is a little trickier. And that's the situation about where those sites are. If they are on another federal agency's lands, Park Service, Forest Service, Bureau of Land Management, unfortunately, we still have a legal problem that we have not resolved. And when I say we, I mean the United States government writ large. We're working on it, but we don't have a resolution of that yet. We are close. Since the last time I spoke to you in Omaha, I have a new boss. At that time, I didn't have a boss. I was acting as the Deputy General Counsel. But we now have a new Deputy General Counsel. Her name is Rachel Jacobson. She was formerly the Assistant Secretary of Interior for Parks, Fish, and Wildlife. She has a very distinctive view with respect to this issue. She thinks we do have discretion to address these sites on other federal agency lands. We're working toward that. We're not there yet. We might not get there. And in the meantime, it's a problem. I'll be honest with you, it's a problem. It doesn't pertain in the same way to sites on state lands. So we believe that it's not an impediment to our addressing sites on state lands. So that's the Indian lands issue. I'm talking too much. And the last concern that I wanted to elaborate upon a little bit, and then I'll open this up for questions in a moment, is what's it mean by resulting from past DOD activities? Now, from the beginning, we thought that was sort of self-evident. It's the stuff we left behind, and particularly in World War II, and particularly with respect to unexploded ordnance in the lower 48, it's the stuff we left behind at the end of World War II. We did an awful lot of training of airmen during World War II on Indian lands. They dropped lots and lots of practice bomb. They dropped quite a bit of live ordnance. When the war ended, we left. We didn't take the stuff that we dropped with us. And so we're in the process of trying to address those things. And then any of you who have been to this state and been out beyond the confines of Anchorage know that there are World War II era facilities everywhere, because we thought the Japanese were going to invade. In fact, they did try, and we left a lot of stuff behind again before the time the war ended. And with respect to those kinds of things, what we need is some evidence that it's attributable to our past actions and no intervening cause. That is, something hasn't occurred between then and now which would make a third person or a third party the more responsible entity. So if you had a World War II facility that was transferred to some commercial concern and used for 5, 10, 15, 20 years between World War II and now, there's at least a question about, did they create the problem or did we create the problem? And we have to sort through those issues. Lastly, let's talk a minute about the beneficial use issue. As Maureen indicated, we had a very extensive discussion with the Corps of Engineers over this concept and what it would mean. And the bottom line really, I think, is this for now. It's an evolving concept, but we think we've come a lot closer to reaching an agreeable circumstance with our Corps of Engineers execution agents. And first, we don't believe that beneficial use should necessarily be disqualified in terms of eligibility for the NALEMP program. And we reached that conclusion for a few reasons. One is we were trying to give voice to the congressional language, and we believe it's pretty clear that Congress intended that we clean up the places that clean up the things that we left behind, the problems that we created through our past actions, and not really to be looking to find ways to say no, but instead looking for ways to say yes. That's the intent of this program. Secondly, we believe, as I mentioned earlier, that the federal trust doctrine, while it may not be legally enforceable, creates this independent source of authority to address these concerns through the NALEMP program. So when you layer the federal trust doctrine on top of what we understand to be Congress's intent, we think that's pretty powerful in terms of providing us the authority to proceed with this program. Thirdly, and it's kind of important, in a circumstance where history is important. So we're going to look at when the property transferred from the federal government to the tribes, with the understanding that if that property transferred to the tribes between, say, the end of World War II and about 1970, for those of you who know your Indian history, your Indian law history, I should say, you recall that that was a good share of that time was the termination era, when it was the official policy of the United States government to terminate government relationships with tribes. And more than 100 tribes were in fact terminated and lost their tribal land base. But the upshot for interpreting our program authority is, if the property was transferred during that termination era, we have to be mindful of the fact that there was a dramatic disconnect between the authority possessed by the United States government and the authority possessed by the tribes. They were at their nadir in terms of strength or authority in those negotiations. So it really wasn't reasonable to expect a tribe to say, we'll take that property from you, but only if you demolish these buildings, only if you clean up this contamination. It just wasn't reasonable to expect that a tribe would have demanded that of the United States government. The tribe didn't have the sense that they had the authority to do that. They were grateful to have the property. The tribal land base had become so diminished from the 1800s to the end, to the termination area that we're talking about here, that a tribe was not going to turn down an opportunity to add to their land base. And so they took the property as is, where is. And so the fact that they took that property with perhaps buildings left behind by the United States government and then did what people would do intuitively, they used them for whatever they could, whatever purpose they could, should not be disqualified. Should be recognized for what it is. People with perhaps fewer options making the best of the situation. And that, in my mind, it pertains whether that use was intermittent, incidental, or whether it was long-standing. It doesn't seem to me it ought to make a big difference in terms of how we interpret our authority under this program. And so the way we resolve this with the Corps of Engineers is that we're going to continue to have the discussions we've been having with our Corps field representatives as well as the folks at Corps headquarters. We are hopeful that we'll reach mutually agreeable conclusions in every case. We're optimistic. But if that doesn't happen and there's a disagreement between our Corps execution agent and OSD, OSD will make that final determination. And if the Corps of Engineers remains uncomfortable with the determination we've made, our office, my office, the Office of the Deputy General Counsel, will write a legal opinion outlining why we've concluded as we have that we hope will provide the top cover for the Corps of Engineers contracting officers so that they'll proceed with administering the cooperative agreement. And we're going to make those determinations case by case. It's a little hard to create a bright line in these circumstances. And I'll just be fair with you. These are the kind of things we're going to be looking at. We're going to look at that history, when the property was transferred. That is important in our estimation. We're going to look at whether any representations or disclosures were made at the time the property was transferred. We're going to think about whether the use was incidental and sporadic or calculated and continuous. I'm not saying these are determinative either way. I'm just saying these are factors to be considered, and they'll all be stacked up and weighed. We'll be looking at the environmental concern, whether there's some inherent threat or hazard associated with the material that was transferred, asbestos, lead-based paint, PCBs, whatever. And then these are potentially disqualifying circumstances. If the tribe or some third party did something between the time the property was transferred by the federal government and present day when you're seeking authority to proceed with cleanup under NALEMP, if something was done by the tribe or the third party that is the actual intervening cause of the environmental problem, that's not eligible. I haven't seen that circumstance yet, with a couple of possible exceptions with, I believe they were above ground storage tanks that were leased to commercial third parties, and the leakage occurred during their tenure. And then lastly, it's a little late to talk about this, and I've been involved in some of these decisions earlier. It's always easier to address these problems incidental to a larger project. So if we're doing, we have another project going on with you all on your lands, and we can just tack this on, it's a lot easier to do it than to try to address these problems separately. Because when we address them separately, it's in the starkest contrast and the hardest to make a decision. Realize this, just a little empathy for us. The language says Indian lands. The language says what it says with respect to each of these issues. We're trying to interpret it as broadly as we possibly can to affect the cleanup on your lands. But presumably there were limits, and we need to be mindful about where they might be, so that we don't have anyone in Congress criticizing the expenditure of the money we've given. Very quickly, I know I've heard it expressed here that you'd like more money for the program. Yes. More staff, yes. How would that happen? Well, you all can do whatever you do to try and encourage your representatives in Congress to do what they do. For us, we can't lobby. What we could do is seek permanent legislation for the program because, as you know, there is no permanent legislation on the Authorization Act side with respect to this program. We rely year after year after year on the largesse of Congress. And they've been good to us, obviously. They've been providing the appropriation year after year after year, but nothing says they'll continue to do that indefinitely. One way of making that happen would to create permanent legislation and then budget more money against that permanent legislation. Because you really can't do one and not do the other. You can't create permanent legislation and then not step up to the plate and actually ask for funding annually to satisfy the requirements of the program you've created. That would have some advantages. It would give us a vehicle for clarifying in legislation the interpretations that I just walked you through that we've given to the legislation over the years. So there would be no one who could step in and say, are you guys crazy? How'd you reach that interpretation? Instead, we could point to the legislation and say, well, Congress provided for it in that legislation. So there are some advantages. There are also some disadvantages to seeking permanent legislation. First, it would draw attention to the $12 million that we're now getting annually. Right now, that's sort of under the radar. It's been done for so many years, it happens almost automatically without anyone paying any real attention to it. If we were to propose to Congress permanent legislation, then they'd start asking about, well, where'd that $12 million come from? Shouldn't you be, DOD, finding ways to come up with the $12 million? Not necessarily expect for us to throw money your way each time. So out of the top line, you got to find $12 million in offsets. $12 million isn't much money. It's dust to the DOD budget. But when you start drilling down and you get all the way down to Marine, and you say to her, find $12 million from your programs to offset the $12 million going to NALEMP, that's a different matter. I put as a con, create need to budget for the program. I think that's a pro and a con. I don't know which side I come out on. Lastly, there has been over the years some value in having language as general as the Annual Appropriation Act has been, because it has allowed us to make creative interpretations, enter into creative interpretations year by year to address the problems you brought to our attention. So if you create permanent legislation, you're really trading certainty for that flexibility that you previously had. So I don't know where I come out on this, but I just wanted to give you a few thoughts here so that you can think about how you come out. And you can read this. This is what we think about our program. We think we've been rational. We think we've been thoughtful. We think we've been conscientious. And I know every year when we come together for these annual meetings, we hear about concerns, things that you don't understand and you don't necessarily believe were decided appropriately. But it's a big program. And think about it just a bit. We spent a lot of money. We've done a lot of good. There are some issues at the margins that we'll wrestle with. We're wrestling with now. We'll probably continue to wrestle with as the years go on. But that should not take away from, I think, our collective conclusion that we have created and administered a program that is done well. It's done a lot for the tribes. It's done a lot in terms of strengthening the relationship between the Department of Defense and the tribes. And frankly, within the federal family, other federal agencies have looked at what we've been doing, and they have taken from that themselves. And so it has, I think, benefited the tribes with respect to other federal agencies who are familiar with the way we administer the program. So I'm not bragging, but by the same token, I'm not apologizing. We've done the best we could. And I'll end with this. I am thinking about retiring. I'm old, you know, and there becomes a time for all of us. I'm not anxious to leave. I like the work I do. I've been privileged to have been allowed to, as the years have gone by and our office has grown from just me to 6 lawyers, I've been able to slough off the work that I don't really care for and keep the work that I like. Who else can say that? I mean, that's pretty nice, and they pay me to do it. And I'd like to continue to do it. The work that I do now means a lot to me. And central among that, central within that portfolio that I am responsible for has been the relationship between the Department of Defense and Indian tribes and the administration of this program. And it has been remarkably significant to me that I've been allowed to work with you all to try to accomplish what we've done. I'm going to leave, but what I will promise you is I'm not going to one day be at work and the next day not be at work, and they'll be wondering where I went. I won't let this program founder. So to the extent that I can share with my successor the conversations that we've had and the rationale for reaching the conclusions we have, I will do that, and I'll stay engaged as long as I can. But I just want to take a moment to thank you all for being really wonderful partners with us in this program. We've had differences, but they're small in number. And it has been remarkably and wonderfully rewarding for me, and I thank you all. So with that, any questions that I might? Yes, Steve?